All right, good morning, everyone. I'm going to call to order the Martin County Magistrate hearing for December 18th, 2024 at 9 a.m. If you'll please rise, join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, please be seated. The first case I'm going to take is the top of the second page on the docket. It's case number GMD 2021-070098. And probably going to struggle with these names, but Inamul Perez Butt and Maria Perez looks. Okay, and Mr. Mitchell, you're going to testify. If you raise your right hand, do you
Yes, sir.
swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and we're joined by Ms. Elder on behalf of your department?
Correct.
Okay, and of course, Mr. Tui on behalf of the code department. All right, so what have we got? It's a stipulation?
It is a stipulation agreement. We entered into that yesterday afternoon about, yesterday afternoon, we had a signed stipulation agreement. That's the one before you there.
Okay.
I can run through the exhibits real quick to kind of give you a rundown of the prop. Well, first of all, my name is Jerry Mitchell. I've been sworn in. I am a senior site compliance officer for Martin County. The respondents are not present, but we do have a signed stipulation.
Okay.
The property appraiser's record of ownership is going to show the property ownership of Mr. And Mrs. Mr. Butt and Mr. Perez. That's going to be County's Exhibit 1.
Okay.
Aerial view of the subject property is going to be County Exhibit 2. This is a 2021 aerial view showing the location of the property off MacArthur Boulevard on Hutchinson Island. It's also depicting a vegetated lot. On July 8th, 2021, we did receive a complaint that there were clearing activities occurring on the property. Also, that fill material was delivered to the property. At that time, GMD staff conducted a site inspection, and they photographed what they saw then. These photographs were taken by Maddie Gierzak, one of our planners in the Growth Management Department. County Exhibit 3 is showing the fill that was deposited on the property at the time. And County Exhibit 4 is showing the clearing activity. Based on that, a notice of violation was issued to the respondent on July 12th, 21, and that's going to be County's Exhibit 5. In that notice of violation, we cited the Section Code 4.37 land clearing, and also that it has natural resources on the property, so we cited Section Code 4.1B wetland applicability. The respondents did apply for their applications immediately once the violation was issued, and because of it having DEP being involved and everything, we kind of gave them a little bit of time to try and bring the property into compliance.
Okay, quick question. The determination that the land was wetland, how did you arrive at that?
Well, there were mangroves on site on the property, and and we knew that mangroves had been impacted.
Okay.
Yeah, yes, sir. Again, the respondents were working with us. They did apply for their proper permits. They did apply for the land clearing application, which in the process required them to actually have Florida Department of Protection come out and actually do a wetland determination on the property, which it was identified. Okay. And also they had applied for their ex and fill permit as well. However, none of these could be issued until all the approvals had passed or had been approved. So we were kind of sitting in limbo here while they were working with their consultants to achieve compliance with the documents. And basically, no other activity was to occur on the property. However, on July 24th, the Public Works of this year, July 24th, 24, the Public Works Department brought to the Growth Management Department's attention that there was more clearing activity occurring on the property, that a driveway access was installed on the property, and that there was some right-of-way work being done on the property. And so based on that, Matty Gierzak went to the property and advised the people on site, the crew on site that were doing the work, to cease and desist, and they did. But also, the same day, she also flew the property with the Martin County Sheriff's Office. And this is a markup rendition of the photos that she took, which is showing the driveway access that I'm mentioning, the clearing that occurred as well. And just to give you an aerial view of what the property looked like before the driveway access was put in, is going to be County Exhibit 7. So obviously, that was County Exhibit 6. This is County Exhibit 7. So you can see at this County Exhibit 7 in the 2024 aerial is just showing how the property was starting to revegetate on its own, and they impacted it again prior to getting any approvals for any permits.
Ah, okay.
So based on that, I issued a notice of, amended notice of violation and a notice of hearing combined. Actually, that one was issued on September 5th, 2024. Now, in this notice of violation, I cited 4.37 land clearing and procedures. Get to the right page here. Also, section 4.1B, wetland applicability, because they still haven't complied with that. Also, we added section 4.341B, which is the applicability for excavation and fill requiring a permit. And also, we added section 1.55.32B, which is road right-of-way use permits requirements. So in that, we gave them, actually, we gave them until December 13th of 2024 to comply. However, we were working with the respondents. The respondents also hired an attorney by the name of Jeremy Bowerman, who helped facilitate a stipulation agreement that you have before you. So what the county requests is that you accept these exhibits into evidence, and we request that they comply within the time limits that are shown on that stipulation agreement. And they did pay their $575 magistrate fee, so that has been paid. And that concludes my testimony at this time.
Okay, and let me just quickly read through the step. Okay, and do the owners clearly understand that that they can't do more work on the property until they get the necessary permits?
We have stressed that to them very strictly, yes, sir. And they are well aware of where we are on this process right now.
All right.
And again, they did sign that stipulation, and I did sign it as well.
All right, so let's see, they're going to basically obtain the permits that they need prior to June 1st, 2025, failing which, just looking for the fine component.
Yeah, we're asking for $100 a day for every day of noncompliance, yes. Should be in there.
Yeah, I know, I'm sorry, I'm skimming over some of this stuff, so maybe I'm missing it. Ms. Elder, do you know where that is, or were we both looking?
It was in there, and then they just delivered the sign stipulation, so unless they.
Up, there it is, bottom of the second page.
Yeah.
Okay, yeah, so $100 per day for non-compliance, okay, plus additional administrative costs. All right, and the $575 has been paid to the county.
Yes, sir, it has.
Note for the record that Mr. Butt and Ms. Perez have signed the agreement, Without objection, I'm going to accept into evidence the county's exhibits 1 through 8 in this case. And I'm going to find that the stipulation is acceptable, and I'm going to approve it and execute the agreed order. Okay.
Thank you very much.
All righty, thank you.
Your Honor.
Thank you both. You want to grab this?
Chuck's 1 and 2. He's got to go to number 4 because they're here.
Okay,
So
so,
we're going to go 1, 2, and or 3 rather.
so 2,
3,
3,
and 4.
and 4.
Yes.
Okay, got it. Yeah, we're just, we're talking about folks who are here, who have come in. We want to make sure we take you all first so that you're not sitting around all morning waiting. All right. Yeah, let's see. Okay. Next case is top of the first page. It's the Hanley case. It's ENF 2024-070561. Paul and Lynn Hanley are the respondents. This is a permit case, and Officer Ambersetti, you're going to testify if you raise your right hand. Do you swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, and are you the Hanleys? All right, what I'm going to do is, this is a violation case, so we're going to hear from the county first. I've sworn in the officer. He's going to testify, present evidence. If at the conclusion of the evidence, the county has made what the law calls a prima facie case, meaning everything they've presented is correct and leads me to believe that a violation exists, then the burden flips to you. And then I'm going to swear you in, and you can make whatever presentation you want, ask questions, present your own evidence, and then we'll go from there. Sometimes it's really simple. Folks just need additional time. That's fine. You know, you can ask for that. This looks like it was a permit case. Typically, folks just need to get the permit. So we're going to hear from Mr. Ambrossetti, and then we'll go from there, okay? And you're welcome to stand where you are. You can actually sit in that front row over there and watch the evidence presented as well, rather than on that monitor. Then I'll call you back up, and then we'll go from there. All right. Okay. Mr. Ambrossetti?
Thank you, Your Honor. My name is Charles Ambrossetti, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondents, Paul D. Hanley and Lynn F. Hanley, are present. This case concerns the property at 1540 Southwest Sunset Trail, Palm City, Florida, 34990. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Paul D. Hanley and Lynn F. Hanley. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On July 22nd, 2024, an expired permit application letter was emailed to Paul D. Hanley. A copy of that letter is marked as County's Exhibit 2. On July 26, 2024, I inspected the property. At that time, I observed a completed paver driveway without an issued permit. At that time, I photographed the property and left the door tag. The photographs accurately show what I saw then and are marked as County's Exhibits 3, 4, 5, and 6. Exhibit 3 is a front-facing shot of the completed paver driveway. Exhibit 4 is a back-facing shot of the completed paver driveway. Exhibit 5 is the pavers winding around the side of the home. Exhibit 6 is the door tag I left on the door. Based upon the investigation, I issued a notice of violation to Paul D. Hanley and Lynn F. Hanley on August 16, 2024, that is marked as County's Exhibit 7. In the notice, I cited the following Martin County Code violation, Section 105.1, Florida Building Code, permits when required, incorporated by Section 21.1, General Ordinances, Martin County Code, for completed paver driveway without an issued permit. In the notice of violation, the respondent was given until September 30th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. On October 15th, 2024, I checked the permit status and the permit had not been issued. Since compliance was not achieved, a notice of hearing was issued by certified mail on October 22nd, 2024, and is marked as County's Exhibit 8. The return receipt was not received, so on December 2nd, 2024, I posted the property. A photo of the posting and the affidavit of posting are marked as County's Exhibits 9 and 10.
Okay.
No call or letter from the property owner was received within the time allowed. Therefore, I checked the permit status again on December 17th, 2024, and saw that the cited violation had not been corrected. A screenshot of the permit status is marked as County's Exhibit 11.
Okay, and just describe, if you will, what that,
Yes, sir, this is a screenshot of our case management system showing that they applied for the residential driveway. The application had expired on 12/4 of 2023.
okay.
Or rather, it was opened on 12/4 of 2023, but it's in, the application's in expired status. I request that all the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondents, Paul D. Hanley and Lynn F. Hanley, be ordered to comply with the cited provisions of the Martin County Code by January 31st, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. Mr. and Mrs. Hanley, come on up. I'm going to find that a prima facie case does exist, so we're going to hear from you if you'll raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your full name, sir?
All Duncan Hanley.
And ma'am?
Lynn F. Handley.
And your address on the, well, just tell us your address.
1540 Southwest Sunset Trail, Palm City, Florida.
Okay, so it's the same that's on the finding. All right. What do we got?
So, I mean, I don't dispute anything that was given. I thought I'm looking at the comments on the Acela site, I guess it's called.
Marcelo, yeah.
Acela. And I thought complying was going to be, there was a couple other comments before the comment of the expired permit came up, or not the expired permit, the doing the work before I got the permit. It was a one inspection, final inspection job, so the assumption I made, and probably where I made a mistake, was to go ahead and don't go past my first inspection. That's kind of being in the business, what I assumed I could do. So once I got that, I stopped the guy. It's not 100% completed. I still have some work that needs to be done to finish it, but when I saw that notice on there, I assumed I had to come to this hearing. I didn't, and I didn't reach out to the individual that it says to do on here. I went forward with it because I had an opportunity with the material that I was going to lose. So I said to him, you know, it's a final inspection deal. Go ahead and put it in. And then when I got that, I stopped. One of the comments on there, which I sent in through the Acela site with my survey, was that I needed to address the culvert. The county took the culvert out, I don't know, 8, 10 years ago. So there was no culvert, so I took the survey that I had sent in with the permit and put the yard drain and sent a picture in with it showing that there was no culvert, thinking that I was satisfying what was being asked. And then when we got the letter, I knew we had a hearing to go to resolve it.
Okay. Well, unfortunately, hearings are a little expensive, and it sounds like you made some sort of a business decision regarding the materials and
Correct.
obtaining them. Obviously, you got to get your permit and then close it out.
Correct.
I mean, that's how the game is played. If you're in the business somewhere, are you a contractor?
Yeah, I work for a contractor.
Okay, so you know how that's done, and that's not what we got. We've got an expired application, so, all right. And let me just ask the county, do you believe that the Hanleys can get the permit, close it out by January 31st?
I would have no problem with giving them additional time. if
Okay, you mean maybe like another month?
If Your Honor, so.
I guess my question is, and maybe it's to the county staff as well, but they're not sworn in, can the permit actually be closed out?
Your Honor, if I might just add, there is no permit. This is just an application.
I know.
There was never a permit
have
issued,
to
so there
get
couldn't
the
actually be
permit.
inspections or anything on something that wasn't even issued yet.
Absolutely. So is the time frame optimistic?
Without knowing what the building department required, I couldn't possibly give you an opinion on that.
Okay.
Your Honor, if I could,
And I'm informed it's actually Public Works that had the objections to this, so probably February wouldn't be a bad,
Okay.
given the
All right.
holidays. Nothing's going
I
to
don't
happen
need-
between now and the end of the year anyhow, so.
Okay. All right. So let me just look, because I don't want you to fail. I want you to be able to get the permit, get it inspected, and be done. So,
May I?
yes.
As of this morning, when I looked at it, the culvert comment, I believe, is still there. And I thought that was the holdup. I know I need to reapply for it and pay, you know, for a reapplication fee. I'm prepared to do that right now, today. I don't know how to resolve that comment. That comment still says not met, I believe.
Well, I mean, obviously, you're going to have to talk to the building department to do that. And so,
That's been my holdup right there, because I can't solve that. I could solve every other comment that they asked for, but I can't solve that one.
I'll tell you what, I'm going to give you until February 28th
Okay.
to get the permit closed out, get it all done.
I appreciate it.
All right. Anything else you need to tell me?
No, sir. No?
All right. And if you don't have any objection, I'm going to enter into evidence the county's exhibits 1 through 11 in this case. So ordered, and based upon that evidence and your testimony and Officer Ambersetti's, I'm going to find that a violation as charged does exist on the property. I'm going to order compliance on or before February 28th, 2025, failing which there'll be a fine in the amount of $100 per day. And I am going to award costs in the amount of $575 to be paid to the county at the conclusion of the hearing. All right. You can actually take a copy of this with you, and you could probably show it to the building department and as you approach that issue. Thank you. And Ms. Bradley will I'll take care of that for you and get it to you. If you just wait for her.
Thank you.
All right, good luck. Okay, the next case is the next case on the docket, the second case. It's ENF 2024-080068. And let's see, the respondents are Luis Mariano Castro, and I'm not sure exactly the order of the names here. It says Cano, Perez, Flordamala, Ortiz, so. And Officer Ambracetti, you've got this case as well. Whenever you're ready, you can begin.
Yes, sir.
Is there anybody here on behalf of, okay, all right. You heard what happened, the last case. I'll call you up when it's your turn.
I've explained it to them, I'm translating for them.
Okay, all right. So you're going to translate Mr. Ambracetti's testimony?
Correct, to them.
Okay, let me swear you in, too. If you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name and your position
Maria Espaillat,
and
Martin County Code Investigator.
fluent Spanish speaker.
Yes,
Perfect. That's what I needed to know. And you're going to translate for the owners of the property.
correct, and I've explained to them so far everything he will be explaining to you now. They're very aware of what's going on.
Okay,
Okay.
all right. Thank you, Mr. Ambracetti.
Thank you, Your Honor. My name is Charles Ambrazetti, and I've been sworn in. I am a code compliance investigator for Martin County. The respondents, Luis Mariano Cano Castro and Flordalma Ortiz Perez, are present. This case concerns the property at 2957 Southeast Golden Gate Avenue, Stuart, Florida, 34997. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Luis Mariano Cano Castro and Flordalma Ortiz Perez. A copy of the property appraiser's record of ownership is County's Exhibit 1. On August 8th, 2024, an expired permit application letter was emailed to Luis Mariano Cano Castro and Flordalma Ortiz Perez. A copy of the letter is marked as County's Exhibit 2.
Okay.
On August 8th, 2024, I inspected the property. At that time, I observed a shed on the property without an issued permit. At that time, I photographed the property and left a door tag. The photographs accurately show what I saw then and are marked as County's Exhibits 3, 4, and 5. Your Honor, this is a front-facing shot of the property, the door tag that I left, and the installed shed. Based upon the investigation, I issued a notice of violation to Luis Mariano Cano Castro and Flordalma Ortiz Perez on September 17th, 2024, marked as County's Exhibit 6. In the notice, I cited the following Martin County Code violation, Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code, for a shed on the property without an issued permit. In the notice of violation, the respondent was given until November 1st, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. On November 12th, 2024, I checked the permit status and the permit had not been issued. Since compliance was not achieved, a notice of hearing was issued by certified mail on November 19th, 2024, and is marked as County's Exhibit 7. The return receipt was not received, so on December 2nd, 2024, I posted the property. A photo of the posting and the affidavit of posting are marked as County's Exhibits 8 and 9. No call or letter from the property owner was ever received within the time allowed. Therefore, I checked the permit status again on December 17, 2024, and saw that the cited violation had not been corrected. A screenshot of the permit status is marked as County's Exhibit 10. It's a screenshot of our case management system showing the shed was in application phase, and that application has since expired. With that, I request that all the county's exhibits be received in evidence. Based upon the testimony and evidence, I request that the respondents, Luis Mariano Cano Castro and Flordalma Ortiz Perez, be ordered to comply with the cited provisions of the Martin County Code by January 31st, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. Come on up. Good morning. If you raise your right hand, do you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God. Yes? Sí, okay. Gracias. I guess this is somewhat similar to the prior case. Application had been made for a permit, but never paid for and received.
Correct. And I have spoken with them, and they did come to the building department several times. They brought several conditions. However, she said she came not too long ago, and they said they couldn't find her permit in the system. I did speak with someone, and they said that she had just some conditions where she has to turn in a survey and show where it's located. And I told her I could help her with that if she brings in the survey, of course.
Okay. All right. Wow. Do they have anything they want to tell me?
Decirle alguna cosa a él, además de lo que yo le dije ya, que ustedes vinieron varias veces, una vez le dije, y más tiempo quieren pedirle. What they are asking for is a little bit more time, because I believe they're in a CRA, so they might need a little bit more time than 30 days.
All right. And I think like the prior case, I'm going to extend compliance to February 28th.
Febrero 28? Okay. Yes, they're good with that.
Okay. All right. Anything else they want
¿Una
to
otra
say?
cosa que le quieres decir al señor?
Pues que nosotros somos frescos, no sabemos.
Yeah, they're explaining that they're new to this. They really didn't know what they needed to bring or provide.
Okay. Had they been in touch with Mr. Ambrosetti? Did they contact you?
No, Your Honor.
Ustedes
right.
no se habían comunicado con eso.
When you were out there, did you have any contact with them?
No, Your Honor. I knocked on the door and no one answered.
Okay. All right. So I'm just looking for some sort of mitigation. I didn't see it in the other case. Not sure I see it here either. Okay. I think unless there's an objection, I'm going to accept into evidence the county's exhibits 1 through 10. No objection, so ordered. Based upon that evidence and testimony from both parties, I'm going to find that a violation does exist on the property. And I'm going to order you to comply by February 28th, 2025. That means to obtain the permit in this case and have it inspected. If you don't do that by the end of February, then beginning March 1st, there'll be a fine in the amount of $100 per day. Okay. And unfortunately, I think I'm going to have to also award costs in the amount of $575 to be paid to the county at the conclusion of the hearing. And let's see, I'm going to just change the date. I did not, incidentally, on that prior order, Ms. Bradley, I did not change the date. So we need to do that and let the Hadleys know that. All right, thank you. Okay, here's that one. Okay. Ms. Bradley has the order, and she'll get you a copy to take with you, okay? All righty, good luck. Okay, one more case, I guess, Officer Counselor, you've got a case, right, with folks here? And let me grab that one. Let's see.
The one for 1322 Sunshine,
It is
0626.
626. All right, this is case number ENF 2024-050626. And the respondents are Carlos Robles Barreto and Maxima Barreto Lopez. And Officer Counselor, I'm going to swear you in first. Do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. And you heard the last case. We're going to hear from the county first. Then I'll call you up, swear you in, and we'll go from there, okay? All right.
My name is Chris Counselor. I've been sworn in. I am a code compliance investigator for Martin County. The respondents Carlos U. Robles Barreto and Maximina Barreto Lopez are present. This case concerns the property at 1322 Southwest Sunshine Street, located in Stewart, located in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of the Martin County, the property owners are Carlos U. Robles Barreto and Maximina Barreto Lopez. A copy of the property appraiser's record of ownership is County's Exhibit 1. On May 24, 2024, Officer Frank Marcos inspected the property. At the time, he observed a carport covered porch area built without a permit. At the time he photographed the property, the photographs accurately show what he saw then and is marked as County's Exhibits 2 3. And Exhibit 4 is a Google Street View showing that there was no pre-existing structure.
Do we know the date of that street view?
I do not.
Doesn't matter. Go ahead.
Your Honor, on the sidebar, it indicates June 2022.
Okay, yeah.
No, on the evidence, Exhibit 4.
Oh,
Yeah, sorry about that.
on the note, yeah.
Yeah, June 2022 was when the photograph was taken by Google.
Okay, go ahead.
Based upon the investigation, Officer Marcos issued a notice of violation to Carlos U. Robos Barreto and Maximina Barreto Lopez on June 4, 2024, marked as County Exhibit 5. In the notice, he cited the following Martin County Code violation, Section 105.1 Florida Building Code with Section 21 General Ordinances, as adopted by General Ordinances 21.1. The notice of violation respondent was given until July 5, 2024 to correct the violation. I took over the case in November of 2024. After reviewing the case, I saw that no permit had been issued for the work that was done. A screenshot of the property's permit history is County Exhibit 6. There's been no permits pulled for this property. Since compliance was not achieved, I sent a notice of hearing by certified mail on November 6, 2024, and it's marked as County Exhibit 7. The return receipt was not received, so on December 4, 2024, I posted the property. A photo of the posting and the affidavit of posting are marked as County Exhibits 8 and 9. 8 is my posting, and 9 is my affidavit of posting. No call or letter has been received from the property owners. Therefore, I went to the property again on December 17, 2024, and saw that the cited violation had not been corrected. At the time I photographed the property, the photograph accurately shows what I saw then. It's marked as County Exhibit 10, with another shot of the permit history as Exhibit 11. So 10, the structure still exists, and no permit has been pulled. I request that all the county's exhibits be received in the evidence. Based upon the testimony and the evidence, I request that the property owners be ordered to comply with the cited provisions of the Martin County Code by January 31st, 2025, and if not compliance by then, be required to pay a fine in the amount of $100 per day until the violation is corrected. The county has incurred the cost of $575 conducting this investigation, and that concludes my testimony.
Okay. All right. Come on up to the podium. And if you'll both raise your right hand, you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, we do.
Ma'am? Okay. All right. So, yeah, and your full name, sir.
My name is Carlos Robles Barreto.
And ma'am, your full name?
Mi nombre es Maximina Barreto López.
Okay, good. And you've heard what the county has to say. Do you have anything you want to tell me?
So unfortunately, I was not made aware of the situation until last week. I just found this out and want an extension to receive the permits. That
Do you all reside on the property?
She does reside on the property. I do not reside on the property.
Okay. So, all right. So you're the one that actually lives there. And ma'am, what did you do with these notices?
¿Es este nombre?
Yeah, you have to talk into the microphone.
So she says she only realized this notice. I did not see the other notices either, or was made aware of the ones that were left behind beforehand. I guess she just didn't mention it to me, or noticed the notices there.
Okay. Well, unfortunately, that can be a costly mistake. In this case, do you know when the actual structure, the carport structure was constructed?
9 o 10 meses.
About 9 or 10 months ago.
Okay, and did you hire a contractor to do it?
She said she had done the work with her and some family friends, just to construct the carport. Looking at it, it does look like it's connected to the property as well. I guess she did not think she needed the permits to receive them, and did not mention to me that the permits were not applied for.
Okay. All right. So, family, friends. No, as we all know, no good deed goes unpunished. You know, they should have pulled a permit then, and the fact that they didn't is really the issue. Okay. All right, and I think, unless you all have anything else you need to tell me?
No.
Okay. I think what I'm going to do is give until February 28th in this case, just like I did in the other two cases. So without objection, I'm going to find that the evidence submitted by the county should be entered into evidence, 1 through 11 in this case. And based upon that evidence, your testimony and the county's, I'm going to find that a violation does exist on the property. I'm going to order compliance on or before February 28th, 2025, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of the hearing, which means that upon entry of the order, it's payable.
Entonces, ¿qué debo de hacer?
All right, any questions for me?
So either we have to take down the structure or apply for the permits to get this situated?
Yeah, I can't really tell you which way to comply, but essentially, that's true. And, I mean, it looks like it's perfectly good structure, so again, I'm not going to tell you how to comply, but that's essentially it. Okay? And you can take a copy of the order with you if you like. That would probably be best, because you've got to go to the building department to apply for it. You're going to need all the things that everybody has talked about as far as survey and deed and that sort of thing, so. There we go. Thank you.
You can email me or contact my.
All right.
Structure, that also complies.
Perfect, appreciate it.
She'll get a copy of the order. Thank you.
Okay, let's see. Officer Counselor,
Yes.
we'll go back up to the Lewis case. Scott Lewis and Kelsey Lewis. DNF 2023-110300. The respondents are Scott Lewis and Kelsey Lewis. And this is a stipulated case.
Correct.
Okay?
My name is Chris Counselor. I've been sworn in. I am code compliance investigator for Martin County. The respondents, Scott W. Lewis and Kelsey W. Lewis, are not present. This case is a stipulation agreement. The property in question is 6670 Southwest 54th Avenue, located within Palm City, located within Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records, the property appraiser of Martin County, the property owner is Scott W. Lewis and Kelsey W. Lewis.
Okay.
The property appraiser record is County Exhibit 1. So basically, like I stated It's a stipulation agreement. On November 14, 2023, Officer Ben Norman inspected the property. He observed a pole barn that had been modified and built with an additional lean-to without a permit. This is the structure in question. They were issued a notice of violation on December 15, 2023, with a compliance date of June 27th. I took over the case in November and issued a,
November of,
well, he did a notice of, so then I took over the case in November
which year?
of 2024.
Okay. Because the original notice was dated November 15, 23.
Yes, I'm sorry, November 2023.
So a year lapsed.
Correct.
Okay.
I took over the case in November, issued a amended notice of violation on November 14th with a signed NTA. The property owners at that point tried to update the permit, but there were still conditions on the permit that kept it from being issued. And they entered into a stipulation agreement to get the additional time till April 1st. So based upon the testimony and the evidence, I request that the respondents Scott W. Lewis and Kelsey Lewis be ordered to comply with the cited provisions of the stipulation agreement to be complied with by April 1st, 2025, and the $350 to enter into the stipulation agreement has been paid.
Okay. $350 or $250?
$350.
$350. And all right, and if they fail to comply, then the fine is $100 a day.
Correct.
All right. Okay. All right, so let's see, there are 10 exhibits in this case. I've actually gone through each of those
Okay.
as you were testifying, so I'm satisfied that the 10 exhibits in the file are fine, and I'm going to accept them into evidence. Note for the record that the Lewises, Scott and Kelsey Lewis, executed the agreement on December 13th, and Officer Counselor, you have as well on behalf of the county, and does require compliance on or before April 1st, 2025, failing which a fine in the amount of $100 per day will accrue. And note also for the record that $350 in costs have been paid to the county. So I'm going to find that it's appropriate to approve the stipulation and enter into the agreed order as submitted. Okay. All righty. Let's see, you've got a couple more. It's, the next case is the McCusker case. It's ENF 2024-040619. The respondent is Marina L. McCusker.
Yeah, and just for correction, we found out that it's El Marina McCusker.
L. Marina McCusker. Okay.
My name is Chris Counselor. I've been sworn in. The respondent, El Marina McCusker, is not present. She has entered into a stipulation agreement. The property involves, the property of the case is 1253 Southwest Pine Tree Trail, located within Stewart, located within Martin County, Florida. According to the official records of the property appraiser of Martin County, the property owner is El Marina McCusker. County Exhibit 1 is the property appraiser report. On April 18th, 2024, Officer Frank Marcos inspected the property. At the time, he observed a driveway installed without a permit. At the time he photographed the property, the photographs accurately show what he saw then, which is County Exhibits 2, 3, and 4. Based upon the investigation, Officer Marcos issued a notice of violation to El Marina McCusker on May 10th, 2024, marked as County Exhibit 5. And the notice of, they were cited for Section 105.1 Florida Building Code as adopted by Section 21.1 General Ordinances, Martin County. And the notice of violation and response were given until June 10th, 2024 to comply. I took over the case in November of 2024. I reviewed the case and saw that a permit application had been started, which is permit number BLD 2024-060492. That permit was applied for on June 10th, 2024, and it's Exhibit 6. Since compliance was not achieved, I sent an amended notice of violation with a notice of hearing by certified mail on November 13th, 2024, which is County Exhibit 7 and 8. It's the amended notice of violation with the notice of hearing. I have spoken with the property owner, and on December 13th, she entered into a stipulation agreement. So based off the testimony and the evidence, I request that the respondent, El Marina McCusker, be ordered to comply with the cited provisions of the Martin County Code by April 1st, 2025. And if not compliance, by then be required to pay a fine in the amount of $100 per day for every day the violation continues thereafter. The cost of $350 has been paid to enter into the stipulation agreement.
Okay. So without objection, I'll accept into evidence the county's exhibits 1 through 8 in this case, based upon the stipulation and the evidence. I'm going to find that it is appropriate to enter into the agreed order in compliance on or before April 1st, 2025. I see where it was typed 2024 on the front page, but I've initial data. Obviously, we're well past April 1st, 2024. Note also that the stipulation does require a $100 per day fine after that. And that $350 in administrative costs have been paid to the county. And the El Marina McCusker has executed the agreement on behalf of herself and Officer Counselor on behalf of the county. So I'm going to go ahead and enter the agreed order as presented, with the exception of the date of April 1st, 2025 is really what it should be for compliance. Okay. And let's see, got one more case. It's the Luton case. It's ENF 2024-040694. Christina Luton as the respondent. And whenever you're ready.
Okay, my name is Chris Counselor. I've been sworn in. I am Code Compliance Investigator for Martin County. The respondent, Christina Luton, is not present. She has entered into a stipulation agreement. This case concerns the property at 4093 Southwest 66th Avenue, located within Palm City, located within Martin County. According to the official records of the property appraiser of Martin County, the property owner is Christina Luton. County Exhibit 1 is a copy of the property appraiser report. On April 23rd, 2024, Officer Frank Marcos inspected the property. At the time, he observed a pole barn built without a permit. At the time he photographed the property, the photographs accurately show what he saw then. It's marked as County Exhibits 2 and 3. That's his door hanger posting, and that's the structure in question in the back. Based upon his investigation, Officer Marcos issued a notice of violation to Christina Luton on May 10th, 2024, marked as County Exhibit 4. In the notice of violation, the property owners were cited for Section 105.1 Florida Building Code as adopted by Section 21.1 to obtain a permit for the unpermitted structure. In the notice of violation, the respondent was given until June 10th, 2024 to correct the violation. I took over this case in November of 2024. After a review of the case, I saw that no permit had been issued for the structure, so since compliance was not achieved, I sent a notice of hearing by certified mail on November 13th, 2024, and marked as County Exhibit 5. That's us. That's the permit status. County Exhibit 6. Sorry.
5.
Yep.
I have it as Exhibit 5.
Yes.
And actually, it's clearer on my screen than it is on the one I'm looking at, over here. Let me just,
A permit was applied for on December 4th, 2024. A screenshot of the permit status is County Exhibit 6.
no. 5.
I have them, okay.
Permit status is 5. Signed NOV is 4. Signed NTA is 6.
Yeah, I got them.
Okay.
Yep.
All right. As long as we're talking about the same stuff.
The return receipt was not received, so on December 4th, 2024, I posted the property, a photo of the posting, the affidavit of posting on County Exhibit 7 and 8. Posting on the front door, and my affidavit of posting.
Okay.
On December 17th, we had a meeting with the property owners. They agreed to enter into a stipulation agreement. Based upon the testimony and the evidence, I request that the respondents, Christina Lutton, be ordered to comply with the cited provisions of the Martin County Code by April 1st, 2025. If not in compliance, by then be required to pay a fine in the amount of $100 per day until the violation is corrected. The fee of $350 has been paid to enter into the stipulation agreement.
Okay, and I'm going to note, too, that there are additional exhibits, 9, 10, 11, and 12, 13. 13 is the permit status.
Yeah, basically, because they didn't enter the stipulation agreement until yesterday, I had gone out and inspected the property and taken additional, so Exhibit 9 are pictures from December 17th, which is Exhibit 9 through 12. And then Exhibit 13 is the permit status as of yesterday.
So without objection, I'm going to accept into evidence the county's exhibits 1 through 13 in this case. In reading the stipulation, it does recite compliance requirement on or before April 1st, 2025, failing which a fine in the amount of $100 per day will accrue, and that the respondent has paid $350 in administrative costs to the county, and it's executed by Christina Luton on behalf of herself and Officer Counselor on behalf of the county to obtain a permit for the pole barn with slab. And so I'm going to find that it's appropriate to enter the agreed order in this case. And so ordered.
Thank you.
Thank you.
This one?
Okay, let's see. What do we got? We got a tag team. Officer Carrasco, you're going to testify on the Gellin case? Is that
Yes, sir.
what we're looking at next? Okay, all right. So if this is case number 2024-100358, and the respondent is Marie Carmel Gellin. And Officer Carrasco, if you raise your right hand, do you swear or affirm the testimony I'm about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Whenever you're ready.
My name is Deborah Crosco, and I have been sworn in. I am a code compliance investigator for Martin County. The respondent, Marie Carmen Gellin, is not present. This case concerns the property at 3920 Southwest Briarbrook Way, Palm City, Florida, in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Marie Carmel Gellin. A copy of the property appraiser's record of ownership is County's Exhibit 1. On October 18th, 2024, I inspected the property, and at that time, I observed high grass. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibits 2, which is the high grass, and 3, which is also another angle of the high grass. Based upon the investigation, I issued a notice of violation to Marie Carmen Gellin on November 8th, 2024, marked as County's Exhibit 4. In the notice, I cited the following Martin County Code violations. Section 76.201, nuisance declared weeds, undergrowth, general ordinance of Martin County Code. I'm sorry?
You said 76.
Oh, I'm sorry, 67.201A. In the notice of violation, the respondent was given until November 22nd, 2024, to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and notice to appear was issued by certified mail on November 26th, 2024, and is marked as County's Exhibit 5. The return receipt was not received. No call or letter from the property owner was received within the allowed time. I went to the property again on December 2nd, 2024, and posted the property as well as the county admin building. And that is exhibits, the property cited violations had not been corrected, and they are County's Exhibits 6 and 7. I also photographed the property on December 17th. The photographs accurately show what I saw then and is marked as County's Exhibits 8 and 9. It's also the tall grass from the two different angles of the.
That's a lot of tall grass.
It is. I request all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent, Marie Carmel Gellin, be ordered to comply with the cited provisions of the Martin County Code by December 31st, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. This occurs to me, is this your first presentation here?
Here, yes.
That's what I thought. You know, I forget that I've known you for many years, so I in another context with the city. Okay, great. Well, good job. Let's see. And nobody's here on behalf of
No.
Marie Carmel Gellin, right? Looking out, seeing no one. I'm good without objection, then I'll accept into evidence the county's exhibits 1 through 9 in this case. Based upon that evidence and your testimony, I will find that violation as charged, 67201A, does exist on the property. In order compliance on or before January 31st, 2025, failing which, fine in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing, and it is so ordered. Okay, good. Thank you. Okay, Ms. Switzer.
Morning.
Good morning. If you raise your right hand, do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, let's see, we got case number ENF 2024-03207-01. And the respondents are, if I can find them, looks like Evelinita, Yvette, Kevin. I can't tell who's
It's
who
Kevin
where.
Avalandia.
Where that starts and where it's.
Yeah, and then Yvette Gomez Castellino.
Okay. All right. Apologize for that. There must be a better way to be doing this, but. All right. So first name Kevin Avalanita
Correct.
and Yvette Gomez Celestino.
Yes.
All right. Looks like the application for certificate of title attached has it. Hey, whenever you're ready.
Okay. My name is Kelly Switzer, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondents, Kevin Avalandia and Yvette Gomez Castellino, are not present. The owners have entered into a stipulated agreement. This case concerns the property at 5545 South Kenner Highway, Lot 44, Stuart, Florida 34997. This case was not generated from an anonymous complaint. According to the official records, the certificate of title of Martin County, the property owner is Kevin Avalandia and Yvette Gomez Castellino. A copy of the certificate of title is County's Exhibit 1.
Okay.
On March 13th, 2024, I inspected the property and found a mobile home with a new air conditioning unit and a covered patio installed without a permit. At the time I photographed the property, the photograph accurately shows what I saw then and is marked as County's Exhibits 2 and 3. That's the covered patio. And then that's the new AC unit. Oop.
Okay.
Based upon an investigation, I issued a notice of violation to the owners on August 6, 2024, and is marked as County's Exhibit 4. In the notice, I cited the following Martin County Code violation, Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1, General Ordinances, Martin County Code. A notice of hearing was issued by certified mail on November 15, 2024, and is marked as County's Exhibit 5. The owners have entered into a stipulated agreement on December 17, 2024, to be in compliance by February 28, 2025, and the agreed fees in the amount of $350 have been paid in full. And this concludes my testimony.
Okay. You. All right, so looking at the stipulation, it does require compliance on or before February 28, 2024, along with a fine of $100 per day thereafter, if not in compliance. And we've heard testimony that the $350 in administrative costs have already been paid. Note that the stipulation is signed by Kevin Avalanita. And Ms. Switzer, you're signed on behalf of the county.
Yes.
All right. Okay, very good. All right, so I'm going to find that the stipulation is in order, and I'm going to, did I accept into evidence the county's exhibits 1 through 5? If I didn't, I intend to. Without objection, it's so ordered that those exhibits are in the case, and based upon that, I'm going to find that it is appropriate to enter the agreed order. obviously you had some contact with them.
Correct.
Did they just,
It's just waiting on it. They submitted a permit, but it was waiting on applicant. So they had some issues on it that they needed to address.
all right. Okay, so that should give them plenty of time.
Yes.
Okay. All right, thank you. Let's see. All right, and the next case is the Keller case. It's ENF 2024-070694, and the respondent is Arlene Keller. And again, whenever you're ready.
My name is Kelly Switzer, and I've been sworn in, and I'm a code compliance investigator for Martin County. The respondent, Arlene Keller, is not present. This case concerns a property at 7739 Southeast Fork River Drive, Stuart, Florida 34997. This case was not generated from an anonymous complaint. According to the official records of the property appraiser, Martin County, the property owner is Arlene Keller. A copy of the property appraiser's record of ownership is County's Exhibit 1. On July 29, 2024, I inspected the property, and at the time, I observed overgrowth, trash, and debris, and along with what appeared to be an inoperable vehicle. At the time, I photographed the property. The photographs accurately show what I saw then and is marked as County's Exhibits 2 through 4. So this is along the side of the home. Over here is the tall grass.
On the right of the photo.
Correct.
Okay.
This is what I thought to be the inoperable vehicle, along with trash,
Exhibit 3.
overgrowth. And then this is just an overall. There's stuff under the carport, the tall grass here.
Exhibit 4. Okay.
Okay. A follow-up inspection was conducted on August 14th, 2024, and found the violations still remain. The exhibits from my follow-up are marked as County's Exhibits 5 through 7. It's just more tall grass. Trash and debris laying around, the inoperable vehicle. And 7 would be just another one of the carport. Based upon the investigation, I issued a notice of violation to Arlene Keller on August 15, 2024. The notice of violation is marked as County's Exhibit 8. In the notice, I cited the following Martin County Code violations: Section 67.201B, nuisance declared, trash, etc., general ordinances, Martin County Code, and Section 91.34A, generally inoperable vehicles, Martin County Code, and Section 67.201A, nuisance declared weeds, undergrowth, which are now both in compliance.
Which,
The last two. The first, the only one I have is for the trash.
okay.
In the notice of violation, the respondent was given until September 5th, 2024 to correct the violations and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on October 23rd, 2024, and is marked as County's Exhibit 6. The return receipt was not received, therefore I posted the property and at the Martin County Administrative Building. My posting and the affidavit of posting are marked as County's Exhibits 10 and 11. There's the posting and my affidavit. Made contact with the owners on the day of posting, and they stated they were working on getting it cleaned up. Therefore, I went to the property again on December 17th, 2024, and saw the cited violations had not been corrected. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibits 2 through 14. Or, I'm sorry, 12 through 14. So there's more trash. There's just another angle. There's more trash behind the truck. And then underneath the carport as well.
Okay. Yeah, looks like they're making some effort.
Yes, but not all the way.
All right. I'm sorry, the Exhibit 13, the SUV,
Yes,
is that now determined to be operable?
correct. When I was out there yesterday,
Okay.
he started the vehicle for me. I requested all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent, Arlene Keller, be ordered to comply with the cited provisions of Martin County Code by January 31st, 2024, and if not in compliance by then, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 every day the violation continues thereafter. The county has incurred a cost of an amount of $575 in conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing. That concludes my testimony.
All right. You were out there talking to them?
Yes.
You were not able to get a stipulation?
Finances were an issue for them.
Well, we're about to make it worse.
I explained that.
Okay. All right. So nobody here on behalf of Arlene Keller, and this is a violation case. So without objection, I'm going to accept into evidence the county's exhibits 1 through 14 in this case and order compliance, find that it's the violation as charged does exist on the property, order compliance on or before January 31st, 2025, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. Okay.
Okay, thank you.
Yes, ma'am. Thank you. All right, I have, let's see, a couple of other orders here. We're removing the next 2 cases. And then the Calvert case, that's yours? Ms. Bradley?
Yes.
All right. Phyllis Comback.
It's under Phyllis.
Oh, it is?
Yes, sir.
All right, okay.
I'll make it make sense here in a second for you.
Sorry, I just got confused when I saw an entirely different name. Okay. Hang on just a second. I'm right there. All right, Ms. Bradley, if you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Whenever you are ready.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 4211 Northeast Cherry Drive, Jensen Beach in Martin County, Florida. On October 21st, 2009, a stipulation and agreed final order was issued by the Code Enforcement Magistrate to Phyllis M. Kalabak for Section 105.1 FBC permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code. And Exhibit 1 is the property appraiser showing that Janet Calvert is actually now the new property owner. Exhibit 2 is the stipulation agreement that was put in place back in 2009.
Okay.
Compliance was required by April 21st, 2010. On December 2nd, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of,
03?
oh, Exhibit 3 is missing. Hang on, I'll get it for you. It's because it was that recording at the time.
Ah.
So there's the recorded affidavit of compliance with accrued fines, reflecting an outstanding fine in the amount of $532,600.
Wow.
And I will put that in for you, so it will be Exhibit 3. I'll get it put in the case.
Okay.
Janet Calvert is the current owner of the property pursuant to a trustee's deed recorded in Official Records Book 3432, page 21, 110, Martin County, Florida, Public Records. The respondent has no remaining interest in the property. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation. However, they have brought the property into compliance and offered to pay $25,798 to resolve the outstanding fines which have accrued. In addition, staff has considered the $257,980 assessed property value. So for this one, we went 10% off of the property value.
Okay.
And this is their request for the reduction.
All right. Okay, and stipulation does reflect that, in this case, compliance was required by January 21st, 2010, and then on December 2nd, 2024, an affidavit of compliance with accrued fines, as earlier stated, does exist, and that Ms. Calvert took ownership pursuant to a trustee's deed, and that the assessed value is $257,980. Okay, I'm going to find that it's appropriate to agree to a recommended order in the amount of $25,798 to resolve the outstanding fines, particularly now that the property is in compliance. Note for the record that Janet Calvert has executed this electronically on December 5th, 2024, and Ms. Bradley, that you have also signed on behalf of the county.
Yes, sir.
Cool. So let's see, without objection, I'm going to accept into evidence the county's exhibits 1 through 4 in this case. And then I am going to execute the agreed recommended order, which goes to the county commissioner for approval. Okay. All right, next case is the Landis case. It's case number 17-0116085, and the respondent is Mitchell Landis. And this is also a stipulation.
Yes, sir.
And okay, whenever you're ready.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 4966 Southeast Primrose Way, Stewart, in Martin County, Florida. On January 17, 2018, a stipulation order was issued by the Code Enforcement Magistrate to Mitchell Landis for Section 105.1 FBC permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code. Compliance was required by July 17, 2018. On November 25, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $229,600. So Exhibit 1 is the property appraiser showing that Mitchell Landis is the property owner. Exhibit 2 is the original recorded order that was put in place. Staff has determined that a lien reduction is warranted. The respondent was responsible for the violation. However, the property has not been placed into compliance but has been seized in a forfeiture by the Martin County Sheriff's Office, filed in court case 2018-000253CA. The respondent has offered to pay $22,960 to resolve the outstanding fines which have accrued. And Exhibit 4 is a copy of the request for the reduction that came from Colton Landis, who is Mitchell's son. He does have power of attorney for the properties.
Okay. What happened to the seizure case?
The sheriff's department took possession of the property in November.
Okay. And they're not seeking forfeiture?
They've already claimed it.
Well, I guess I'm not understanding then. If the sheriff's department is seeking forfeiture,
It was, to my understanding, it is a forfeiture case. It's pursuant to, I believe, numerous drug violations.
okay, so let me just see what we're stipulating too.
So Colton is paying the fines up to the date that the sheriff's department seized the property. We stopped the fines as of that date because Martin County Sheriff's Office is obviously a Martin County entity. We're not going to keep running fines on something that's ours.
Against yourself.
Yes, so we stopped the fines as of the date that the sheriff's office seized the property through the forfeiture.
And that's
And,
really what I was trying to puzzle
yes,
through.
and Colton is paying, because he's got other property that he's trying to sell. So this was a cross lien that he's trying to rectify.
All right, so basically this just clears that debt.
Yes.
Got it, okay. I'm going to take notice of this final order, judgment of forfeiture executed by Judge Metzger in case number 2018-000253CA, William Snyder, Sheriff of Martin County versus Mitchell Robert Landis. And it does recite that the following property is forfeited to the Martin County Sheriff's Office and shows the Primrose Way property. Although it does
It's a
have
duplex.
different-
It's a duplex, so they listed only the main address. If I pull up the property appraiser, it'll show.
Okay. All right. Okay, it's okay. I'm going to accept your testimony in that matter. And I am going to find that it is appropriate. Let's see, you've got exhibits 1 through 4 plus the final order. So 6 exhibits, if you will. Or 5 exhibits, rather. I'm sorry. And based upon the fine reduction stipulation, I'm going to find it is appropriate to recommend an agreed order to the county commission for payment of $22,960 in this case. The copy I've got does not have Mr. Landis's signature, unless it's back here somewhere. Oh, I've got a, okay. And I'm sorry, I can't tell whether this is a photocopy or the original.
That's the original, sir.
All right. And Ms. Bradley, you want to execute?
I can do that for you.
All right, and I've marked the final order judgment of forfeiture as Exhibit 5 in the case. All right, so note for the record that Colton Landis, attorney, in fact, for Mitchell Landis, has executed, and Ms. Bradley, you've also executed. I'm going to go ahead and approve this to go to the county commission.
Thank you, sir.
Okay, next is the Scaduto case. And Ms. Bush, good morning.
Good morning.
This is case number ENF 2024-060295-01, and the respondent is John Scaduto. Ms. Bush, you're going to testify if you'll raise your right hand. Do you swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, and nobody here on behalf of Mr. Scaduto? Seeing no one, okay. All right. Whenever you're ready, Ms. Bush.
My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, John Scaduto, is not present. This case concerns the property at 2188 Northeast Ginger Terrace in Jensen Beach, Florida, 34957, in Martin County, Florida. This case was not generated from an anonymous complaint, and according to the official records of the property appraiser of Martin County, the property owner is John Scaduto. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On June 25th, 2024, an inspection was completed by code inspector. At the time of the inspection, the code inspector observed high grass, accessory structure damaged where the pool equipment is, and a green pool. The code inspector photographed the property. The photograph accurately shows what the code inspector saw then and is marked as County's Exhibits 2 through 5. Exhibit 2 is the front of the property showing the high grass. Exhibit 3, an additional photo of the high grass. Exhibit 4 is the structure in question, or the structure that's damaged.
Okay.
Exhibit 5 is the pool.
Okay.
Based upon the investigation, a notice of violation to John Scaduto on June 27, 2024 was issued, marked as County's Exhibit 6. In the notice, the following Martin County code violations was cited. Section 67.201A, nuisance declared weeds, undergrowth, ordinances of Martin County, Florida. Sections 21.105, pools, swimming pools, general ordinances of Martin County. Code sections 21.110, general exterior structure, general ordinances of Martin County, Florida. In the notice of violation, the respondent was given until July 11, 2024. To correct the violation, it was informed of the need to contact Martin County Code Enforcement upon doing so. A photo of compliance of the overgrowth is marked as County's Exhibit 7. So that was not, the overgrowth is not on the NTA, as they complied that. And the remaining violations had not been in compliance, a notice of hearing was issued by certified mail on August 14, 2024, and is marked as County's Exhibit 8. Additional time was allotted, and an amended notice of hearing was issued by certified mail on November 27, 2024, and is marked as County's Exhibit 9. The return receipt was not received, and the property and county administration was posted on December 2nd, 2024, and is marked as County's Exhibit 10. I went to the property again on December 17, 2024, and saw that the cited violations had not been corrected. At that time, I photographed the property. The photographs accurately shows what I saw then, and is marked as County's Exhibits 11 through 12. 11 is the pool and the structure still in violation. The property owner called this morning and indicated that he understands that he's not in compliance. He was not able to make the hearing today. And I did advise of what the county would be seeking at the hearing. So at this time, I request that all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that respondent John Scaduto be ordered to comply with the cited provisions of the Martin County Code by January 31st, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 per day for every day the violations exist per violation. The county has incurred a cost in the amount of $575 conducting this investigation, and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. All right, again, anybody here on behalf of John Scaduto? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 12 in this case.
Yes, sir.
Based upon that evidence and your testimony, I'll find that violations as charged, 21.105 pool and 21.110 exterior structure, do exist on the property in order compliance on or before January 31st, 2021, or 2021. We all wish. January 31st, 2025. Failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you, Special Magistrate.
Ma'am, one more. Okay. All right, this is ENF 2024-070328-01, and the respondents are Amy Patterson and Bell Harbor Properties, LLC, as owners of the subject property. And anybody here on behalf of Amy Patterson or Bell Harbor Properties? Seeing no one, go ahead.
Thank you, sir. My name is Tamika Bush, and I have been sworn in. I am a code compliance investigator for Martin County. The respondent, Amy Patterson and Bell Harbor Properties LLC, is not present. This case concerns the property at 8658 Southeast Anthony Way in Hope Sound, Florida, 33455, and Martin County, Florida. This case was not generated from an anonymous complaint, and according to the official records of the property appraiser of Martin County, the property owner is Amy Patterson and Bell Harbor Properties LLC. A copy of the property appraiser's record of ownership is County's Exhibit 1. On July 31st, 2024, I inspected the property, and at that time, I observed work being completed with no permits. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibits 2 through 3. This is a front photo of the property. Exhibit 3 is a permit screenshot, which is not very clear, but They did not have a permit for the work that they were completing there. At that time, there were multiple permits required. All the permits have been resolved with the exception of the AC split unit, which I would show in upcoming photos. So based upon the investigation, I issued a notice of violation to Amy Patterson and Bell Harbor Properties LLC on August 1st, 2024, marked as County's Exhibit 4. In the notice, I cited the following Martin County violation: Sections 105.1 FBC permit when required, incorporated by Sections 21.1 General Ordinances of Martin County Code. An issue permit for the split unit AC is the only permit outstanding and required to comply or remove the unit in order to comply, And in a notice of violation, the respondent was given until September 30th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on September 20th, 2024, and is marked as County's Exhibit 5. An amended notice of hearing was issued by certified mail on November 7, 2024, allowing additional time to comply, and is marked as County's Exhibit 6. The return receipt was not received, and the property in County's administration was posted on November 25th, 2024, and is marked as County's Exhibit 7. On December 16, 2024, the owner and/or representative was offered a stipulation of agreement. A stipulation of agreement and final order was emailed to James McMahon, and he was advised of the ways to make the payment. The stipulation of agreement was not returned, and the payment was not made as of this morning. I went to the property on December 17, 2024, and saw that the cited violations had not been corrected, and at that time, I photographed the property. The photographs actually shows what I saw then, and it's marked as County's Exhibits 8 through 10.
8 is a screenshot, right?
Yes. Exhibit 8 being the screenshot showing that there is a residential trade electrical permit, which is awaiting applicant. That status on Exhibit 8 has been awaiting applicant as of August 19th, 2024. The revisions had not been submitted.
That's for the split unit?
Yes, sir.
All right.
And then Exhibit 9 is a photo of the front of the property. Exhibit 10 showing the split unit, AC. I request that all of the county's exhibits be received into evidence, and based on the testimony and evidence, I request that the respondent, Amy Patterson and Bell Harbor Properties LLC, be ordered to comply with the cited provisions of the Martin County Code by January 31st, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 per day for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, let's see. No one here on behalf of Amy Bell Patterson and Harbor Properties LLC? Still no one, okay. Without objection, I'll accept into evidence the county's exhibits 1 through 10 in this case. Based upon that evidence and your testimony, I'll find that violation of Section 105.1 Florida Building Code does exist on the property, and order compliance on or before January 31st, 2025, failing which a fine in the amount of $100 per day will accrue, and a further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you, Special Magistrate.
Yes, ma'am, thank you. Okay. All right, let's see, that's the docket. There is a set of magistrate minutes for the August 21st, 2024 hearing. Seems like I went through these a long time ago. Okay. I'm going to go ahead and approve those and execute them. Note that Rachel Spradley has signed them on behalf of Jillian Colleen, staff recorder, and that John Colando, as code administrator, has also executed them. Okay. All right, anything else to come before us today?
No, sir?
Nope.
All right,
Next hearing is.
happy holidays to each of you. Our next hearing is January 15th, 2025, and we will see you all then. And with that, we stand adjourned. Thank you.
Thank you.